Welcome to the Probate Nation. My name is Richard Ruddy. When someone passes away, probate of an estate is the process to transfer the title of probate assets to the decedent's beneficiaries. That process is like a journey on a slow-moving steam engine train, and some probate rides are short, while other probates seem to never end. There are several common probate avoidance techniques that convert probate assets into non-probate assets. One such popular technique is the use of a revocable trust to hold your assets. But a revocable trust only helps avoid probate for those assets that are actually titled in the name of the revocable trust, or that are payable to the revocable trust when you die. While doing their estate planning documents, many folks fail to follow through on this critically important step of retitling assets or naming the trust the beneficiary in the course of their estate planning work. In part one on funding the revocable trust, we reviewed some of the assets to be funded into a revocable trust. Tonight we will conclude that discussion with a review of other assets that to be funded into that same trust. With us this evening again is a trust and estate attorney. He will share his observations and suggestions and pitfalls to avoid as we continue this discussion on funding a revocable trust. Our guest is a partner in the Ruddy Law Firm located in Fairfax, Virginia. He has been in private law practice in Northern Virginia since graduating from George Washington School of Law. His practice focuses on estate planning, estate trust administration, and elder law for clients with diverse economic, cultural, and family backgrounds. He also regularly serves as a court-appointed guardian ad litem for adult conservatorship and guardianship matters in Fairfax County Circuit Court. Please welcome attorney David Nur. Hi, David.
Hi, Richard. Thanks for having me again.
You're welcome back. So we're continuing this discussion about funding a revocable trust. So just briefly talk about, what is a revocable trust again, just briefly, and let's get this conversation started.
Sure thing, will do. So a revocable trust is an agreement that creates a fiduciary relationship between the grantor or the creator of the trust and a trustee, who's the person they're asking to hold title to the property or assets that will be put into the trust. And that person is to administer those assets, that trustee is to administer those assets for the benefits of the beneficiaries of the trust.
So a revocable trust, as we've talked about in part one, revocable trust, whatever's in the revocable trust does not go through probate. Okay, so our key thing and what we're talking about tonight is how to put assets into the name of a revocable trust, and we're going to continue that discussion. So we talked a little bit about tax considerations in connection with funding a revocable trust. So just to review for our clients though, our viewers, the non-retirement assets, when they're funded into a revocable trust, is there any tax consequence?
No, there really isn't.
Okay. And they take the same tax basis when they get funded into the revocable trust. But to contrast that, if you try to put a retirement account into a revocable trust, is there a tax consequence?
Yes, that's problematic. That's a taxable event if you were to transfer. It looks like a distribution to the revocable trust, so you don't want to do that.
So we want to stress that if you have retirement accounts, those are things that do not get the title change into the name of the revocable trust. You have to deal with that in a different way. For a revocable trust, do folks typically use their Social Security number to identify the assets in the trust?
Yeah, so they'll be using their Social Security number. That will act as the tax ID number, per se, for the revocable trust.
Good. Okay, so let's go ahead and now get into some of the other assets to talk about in addition to what we talked about in part one. So let's talk about Virginia real estate. In general, how do you put Virginia real estate into a revocable trust?
So it needs to be done by deed. So it'll be a deed of gift or a deed of conveyance into trust. So the grantors will be the person that owns the property. So the individual, or maybe it's a married couple who own it as husband and wife, they will be the grantors, so they will be conveying their interest in that property, often to themselves as the trustees of their revocable trust.
Now, is there any tax issue associated with transferring that real estate into a revocable trust?
No, there's not.
Okay. So Many people have personal residence, is what we would put in the revocable trust to start with. But a lot of times there are mortgages that are encumbering that property. Are there any issues with conveying a residence into a revocable trust that has a mortgage encumbering it?
So as long as it's your primary residence and you fulfill certain requirements under a federal statute, you're fine to put your personal residence in the trust, even if it has a mortgage on it.
Okay. Now, of course, you have a house that's got fire and casualty insurance. Okay, so do we need to notify the homeowner's insurance, the home insurance insurance company that we've transferred the property into the trust, into a revocable trust?
Yes, absolutely. You want to notify them to add your trust as an additional insured on the policy.
Okay.
Because it's now the owner of the property.
Okay. And then is there anything else we need to do as far as how about homeowners associations? Do we need to notify them as well that we've made the transfer?
Yep, that's another entity that you want to make aware of the new ownership of the house. So yeah, you want to make them aware so that they're sending dues to you as the trustee of the revocable trust, who is now the owner of the property.
So let's just talk about one of the real cost benefits of putting your house into the revocable trust. If you don't put your house into the revocable trust, how is it placed into your trust after your death?
So it's one of the big benefits of doing the revocable trust is probate avoidance and the fees and costs associated with going through the probate process. So if you don't actually title the property into the house, what your executor or personal representative, the person who you put in charge under your will have to go to your local jurisdiction's clerk, probate clerk, and they'll have to actually record the will. And typically for our clients, if we do a revocable trust, we do what's called a pour over will, which essentially names the trust as the beneficiary of the will. So then by recording this will, it would then transfer the ownership to the revocable trust.
But one thing for clients to keep in mind, people to keep in mind, is that if you do that, then you have to pay a probate tax.
That's correct.
So if the house you have is worth, let's just pick a number, $500,000, then the probate tax on that particular asset alone is $500.
That's correct.
So by not putting it in the revocable trust to start with before you passed away, you just have added a cost to the process to administer your estate. So it's very important to complete that if you can. Let's talk about non-Virginia real estate. How do we put non-Virginia real estate into a revocable trust? That beach house in North Carolina or down in Maryland or Delaware, how do we put those particular pieces of property into the revocable trust?
So similar to what you do in Virginia, you would do a deed to convey that property. You would have to hire a lawyer who's licensed in the state where the property is located to prepare the deed for you, and you would be conveying your interest in the property into your revocable trust. And I think this is one of the places where having a revocable trust, the benefits of it really shine, because by having the property, that property in, you will say South Carolina somewhere, your vacation house in the revocable trust, that avoids having to do what's called an ancillary probate down in that jurisdiction in order to transfer the ownership of that property upon your death to your beneficiaries.
Okay. Now, again, this property is typical. We're talking about non-Virginia real estate that is not an investment property. It's like a second home or vacation house for the family. Do we have any issues about the property being subject to a mortgage? Do we have to worry about mortgages coming due?
So for a second home, a vacation property, it's going to be treated a lot like the primary residence, and it will follow a similar path. So it shouldn't be an issue.
Okay. And then, of course, we obviously still want to notify the insurance company that we put that fire insurance, that we put the property into a revocable trust. And if there's a homeowners association, let them know that that's been done as well. So let's turn to investment real estate, because this does take a little bit of a different wrinkle here. So a lot of folks do own beach properties. or office buildings, and those are not residences, and they want to put, they're probating, they want to avoid probate on that. Can we go ahead and simply deed that property into a revocable trust, or should we try to place that in an LLC?
As you suggested, we recommend that you put it in an LLC for the liability protection that offers for you. If you put it into a revocable trust, you're putting your entire estate at risk should some toxic situation happen with that property. The LLC offers you some protection. It kind of cuts off the rest of your estate from that potential liability.
So the issue we run into then is typically these beach properties that are being rented out, or office buildings, have mortgages. Okay, so do we have any issue associated with that mortgage that somehow hinders our ability to go ahead and convey that property into an LLC?
You do. Unfortunately, that is an issue, and sometimes it prevents you from making that transfer to the LLC. So without getting written permission from the mortgage from the lender ahead of making the transfer to the LLC, you could run the risk of having them exercise the due on sales clause when you convey the property to the LLC. So you want to get out ahead of that before making any conveyance to an LLC, probably before even creating the LLC, and making sure that they would approve of you making that transfer.
Yeah, so if it turns out that that's an issue, sometimes you have to wait until you decide to refinance the property, and when you refinance it, then you can go ahead and place the property into an LLC. Let's turn towards the next set of assets that we have on our list here, which is, let's just say you're a mortgage lender, or you have a note that someone owes you money on, or you have other receivables. Can that be assigned to your living trust?
It can and should be, because it's an asset of your estate. So it's much like all the other assets that we've discussed over the course of this program. You want to have an assignment prepared to assign your interests in that debt to your revocable trust, so that the trust is the holder of that note or debt instrument.
Yes, and just everybody keep in mind, our viewers keep in mind that there are rules called the statute. There's a rule called the statute of frauds that says if the amount of that note or mortgage, whatever it might be, is more than a certain dollar amount, it has to be in writing. Otherwise, it's not enforceable. Enforceability becomes an issue. So just be careful about that. All right, we don't see this a lot, but we have seen it, over in recent years. What if I own oil and gas or mineral interest in Oklahoma or Texas or something like that? Can these be transferred to a revocable trust as well?
They can, much like other assets. So if you own an interest in an oil or gas or mineral interest, typically that'll be part of the deed conveying the land, or part of a separate deed, and you would have to prepare a deed to convey that interest to your revocable trust. If you lease the right, you may be looking at using an assignment to transfer that interest to your revocable trust. But this does vary by jurisdiction, so you'd have to check with the lawyer in that jurisdiction to find out what would be necessary.
Okay. Well, something that doesn't make its way into revocable trust, but which comes up often in the context of the state administration, is survivor lawsuits and wrongful death claims. So survivor lawsuits, someone gets hit in a car, is in a car accident and doesn't die, and then from that car accident, but while they're pursuing that litigation, something happens and they do pass away from other causes. Okay, so somebody has to continue that litigation. Can that survivor lawsuit be assigned to a revocable trust?
No, that is not an interest that could be assigned to the revocable trust. What you'd be looking at there is having the executor of the decedent's estate continue that lawsuit on their behalf. But no, it's not an asset that can be transferred to the revocable trust.
Yeah, so typically that person would go to the courthouse and get qualified for the purpose of actually continuing that lawsuit. So
that's correct.
So a separate issue, though, is let's just say someone's in a car accident and is killed, so that becomes what's called a wrongful death lawsuit. That doesn't really go through that doesn't really go through probate or even go to the revocable trust, but they still got to pursue the lawsuit. Do they need to go to court and get qualified to do that?
Yeah, much like the first situation with the survivorship, you'd have the executor go and bring that wrongful death suit, and then the proceeds would go to the beneficiaries based on the outcome of that lawsuit.
Yeah, it's important to note that in wrongful death lawsuits, a lot of times those proceeds that are recovered never go through the estate, but the estate has to actually bring the lawsuit as a matter of law, at least in Virginia. So just keep that in mind. Let's talk about closely held business interest. Many clients have, a closely held business, either an LLC or a C Corp or an S Corp. Can the ownership of those entities be placed in the name of their revocable trust?
Yes, they can. In short, I think it gets a little more complicated based on, a buy-sell agreement that may be a part of the corporation, or if it's a professional corporation or professional limited liability company, that, if it's a professional organization, it requires that somebody of that profession be part of the ownership group, in which case you couldn't do the transfer to your revocable trust.
Okay. So sometimes those buy-sell agreements can be tricky. It's very important to take a look at those because frequently people don't want the asset to be transferred after someone dies. And if you actually transfer it to a revocable trust, typically you'd want to have the revocable trust then become a party to that buy-sell agreement so that they are bound by the terms of that. Are there any tax issues associated with putting a stock interest or an LLC interest into a revocable trust?
No, there isn't.
Okay. So is there an alternative to actually putting the stock certificate in the name of the trust that we could use if we have some sort of restriction that prevents us from actually doing that while you're alive?
There is, and I'm glad you brought this up. So we touched on it a little bit in a previous segment about transfer on death designations. So you could use a transfer on death designation on the stock certificate, for example, with the corporation, to designate a beneficiary to receive that ownership interest upon your death. So that a transfer on death designation could be a useful way of doing that in this circumstance.
Sure, and that's especially helpful with professional entities that might have restrictions on who can own stuff, own assets. Let's talk about, we talked earlier on at the very outset of both of these programs about the importance of not transferring retirement accounts into the name of your revocable trust. But, so they're never actually placed. But how do we actually dispose of those retirement assets when the participant dies?
So this can sometimes be a complex area of planning. It can be very simple at times as well. It kind of depends on a person's situation. Typically, you'll name a spouse as the primary beneficiary of a retirement account, and then you may name adult children as the contingent beneficiaries. And you do that oftentimes to take full advantage of, with the spouse, the rollover that she's permitted to do under the tax code, or for the children to make sure that they get the full extent of the 10 years that are allowed to them as beneficiaries.
Okay. So that's, and I think you mentioned the 10-year payout. That's a big change beginning in, I think it was January of 2020.
Yes, that's correct, the Secure Act.
And so that became a real planning tool. So you have to consider that payout obligation in conjunction with the disposition of your other assets so that the kids maybe don't get all the assets all at one time. Now, can a revocable trust and now an irrevocable trust, when you passed away, can it be the beneficiary of a retirement account?
It can, but it really needs to be a trust that's designed in order to act as a beneficiary of a retirement account. It requires a lot of special drafting to make sure that the trust agreement is crafted in such a way that it's not going to run afoul of some of the IRS rules regarding designated beneficiaries.
And you mentioned that the need to be careful, because what we're trying to preserve at this point is to make sure that we meet the requirements so that we remain eligible for the 10-year payout.
That's
as
correct.
opposed to if it's not done properly, then you're going to be stuck with a 5-year payout, which means you're going to take more income into income sooner, and that's
That's correct.
not a good thing. Well, let's continue again with the question is, what are some of the common problems that you have encountered with funding the types of assets we've discussed tonight into a revocable trust?
So again, I think one of the issues is people updating their beneficiary designations. So this is especially something that's true with retirement accounts. So it's critical, to double check that these have been updated. Sometimes, the youngest child may not be named as a beneficiary on these accounts. So that's something that's worth double checking and making sure is correct.
How about the importance of taking that beach house and making sure that that gets retitled so you avoid ancillary probate in Georgia or South Carolina or North Carolina?
Yeah, that's critical as well. So, you know, it, we talked about the revocable trust as being this tool to avoid the process and the cost of probate. So that's true in another state where that beach house may be located as well. So again, to take full advantage of doing the revocable trust and the benefits that it offers, you need to make sure that your vacation home, just as much as your primary residence, is put in the revocable trust.
And I would share with our viewers that we've done a number of programs over the last several months about ancillary probate in other states like Georgia, like Maryland, and so on. And we wanted to just remind people that it can be very beneficial to get those assets retitled into your revocable trust before you passed away. You can avoid not only ancillary probate, but possibly state income tax or inheritance tax issues as well. Well, I think we've covered a lot of ground. There's not a lot of time left, unfortunately, to continue this discussion, but I wanted to give you a chance to share any closing comments or words of advice you might have for our viewers.
I think I was going to take a moment to talk about some assets that are sometimes overlooked as part of the estate planning process. And so one I was going to pick up on is digital assets. I think more and more of what we do in our lives and even things that we own are in digital nature. So I think people often overlook things such as digital photos that they have, videos, maybe they have music that they own or video, movies, other types of digital content that they own. Lots of people have Facebook pages or other social media accounts that they actually have a value to the decedent and to the family. And so I think it's important to, through your estate planning, also account for these types of digital assets as well.
Those are good suggestions, David. I want to thank you for taking the time again to visit with us today and to share all this valuable information and for your public service to the folks across the Northern Virginia communities. Thank you on behalf of the Probate Nation.
Thank you, Richard. My pleasure.
Avoiding probate is certainly a popular planning objective both for lay folks and the estate planning attorneys who advise them. And one of the most popular and effective ways to avoid probate is to create a revocable trust to hold your assets and then actually fund those assets into that trust. Over the course of 2 shows, we have reviewed a number of the most common assets held in estates and how to retitle or lease control by beneficiary designation into your trust so that you can avoid probate of that asset. But I want to stress and strongly that each trust funding situation is different. I encourage you to follow up with your trust and estate attorney to review your trust funding progress to date and update that review periodically so you can get your trust properly and fully funded. In our experience, such professional advice will be well worth the time and the effort and in the long run will keep your assets off the probate train. This brings us to the conclusion of our 2-part series on funding the revocable trust. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. And we encourage you to sign up to receive the monthly Probate Nation newsletter. On behalf of the Probate Nation, thank you for visiting with us.